This is episode 1 of What I Learned Today, how the Supreme Court utilized the shadow docket to allow the Department of Homeland Security to continue unlawful seizure based on racial profiling. This summer, individuals and organizations, the plaintiffs, brought a lawsuit against Noem in her capacity as the Secretary of the Department of Homeland Security. The plaintiffs sought a court order preventing ICE from conducting roving patrols, detaining individuals without reasonable suspicion, and denying them access to lawyers. In the early stages of the lawsuits, the plaintiffs sought a temporary restraining order that would prevent the federal government from engaging in these suspicionless stops while the lawsuit was pending. After hearing the evidence, the trial court issued a 52-page order granting the plaintiffs' motion for a temporary restraining order. In the order, Judge Frimpong noted that the federal government agreed with the plaintiffs that roving patrols without reasonable suspicion violated the Fourth Amendment to the Constitution, and denying access to lawyers violates the Fifth Amendment to the Constitution. What the federal government would have this court believe, in the face of a mountain of evidence presented in this case, is that none of this is actually happening. The court concluded that this mountain of evidence justified entering a temporary restraining order to cease these roving patrols and denying access to counsel. The federal government appealed this order to the Court of Appeals for the Ninth Circuit. The federal government then filed a motion with the Court of Appeals to stay the temporary restraining order, essentially requesting that the temporary restraining order be put on hold pending the outcome of the appeal. The Court of Appeals denied the motion. The federal government next applied to the Supreme Court for a stay of the temporary restraining order. In essence, they asked the Supreme Court to nullify the temporary restraining order pending the outcome of their appeal. This request was made on the Supreme Court's emergency docket, also known as the shadow docket. On September 8th, the Supreme Court granted this application for a stay. Here I've pulled up the Supreme Court's emergency docket, or shadow docket, order in the Perdomo versus Noem lawsuit. And the Supreme Court gave no reasoning. It simply paused the trial court order, essentially throwing out all of the careful fact-finding the trial court conducted. The outcome is this: ICE can continue to conduct roving patrols and suspicionless detentions, and can continue to deny detainees access to lawyers. So in the guise of an emergency docket order, the Supreme Court allowed the Trump administration to continue its blatantly unconstitutional practices. Now, I didn't go into deep detail about what exactly a shadow docket or emergency docket is that the Supreme Court is using, but I can do that in a separate video. I am trying to make this a series of bite-sized information that I found relatively interesting and relatable to what Americans are facing today. It is still very important for you to conduct your own independent research, but I hope I helped you get started on it. So happy researching, everybody.